Yeah, I'm Narayan and I'm currently pursuing BLLB from University of Petroleum and Energy Studies. I'm in my fourth year and I'm interning under the Lexis and Company. And today in this video, I will be telling you about the authority for removal of organs. So, as per the Transfer of Organs Act, the under the Section 3, the authority for removal of organ is being given, and we will be looking at that. And it says that any donor may, in such manner and subject to such conditions as may be prescribed, authorize the removal before his death of any human organ of his body for therapeutic purposes. Now, if any donor had in writing and in the presence of two or more witnesses unequivocally authorized at any time before his death the removal of any organ of his body after his death for therapeutic purposes, the person lawfully in possession of the dead body of the donor shall, unless he has any reason to believe that the donor had subsequently revoked the authority aforesaid, grant to a registered medical practitioner all reasonable facilities for the removal for therapeutic purposes of that human organ from the dead body of the donor. Now, what if the authority is not being made? Then in that case, if no such authority is made by any person before his death, but no objection was also expressed by such person to any of his human organs being used after his death for therapeutic purposes, the person lawfully in possession of the dead body of such person may, unless he has reason to believe that any near relative of the deceased person has objection to any of the deceased person's human organs being used for therapeutic purposes, authorize the removal of any human organ of the deceased person for its use for the therapeutic purposes. Now, the authority given by the person when he was living, or by the person when there was no objection, uh, there shall be there shall be sufficient warrant for the removal for therapeutic purposes of the human organ, but no such removal shall be made by any person other than the registered medical practitioner. So whenever the removal of organ will be done, it has to be done by the medical practitioner only and not by anyone else. Also, where any human organ is to be removed from the body of a deceased person, the registered medical practitioner shall satisfy himself before such removal by a personal examination of the body from which any human organ is to be removed, that life is extinct in such body, or where it appears to be a case of brainstem death, that such death has been certified under the section 3 under section 3 of the act. Now, where any human organ is to be removed from the body of a person in the event of his brainstem death, no such removal shall be undertaken unless such death is certified in such form and in such manner, and on satisfaction of such conditions and requirements as may be prescribed by a board of medical experts, which shall consist of a registered medical practitioner in charge of the hospital in which brain stem death has occurred, an independent registered medical practitioner being a specialist to be nominated by the registered medical practitioner uh, specified in clause 1 from the panel of names approved by the appropriate authority. Second, a neurologist or a neurosurgeon to be nominated by the registered medical practitioner from the panel of names approved by the appropriate authority. And fourth, the registered medical practitioner treating the person whose brain stem death has occurred. Suppose where brainstem death of any person less than 18 years of age occurs, and is clarified that any of the parents and if the if there is a death of someone who is below the age of 18 by the by brain stem, then in that case any of the parents of the deceased person may give authority in such form and in such manner as may be prescribed for the removal of any human organ from the body of the deceased person. Thank you very much. And in this video, we learn about that how and when cases and in what manner the organs can be donated. Thank you.